Moving along, we are going to talk about the Open Meetings Act. So welcome. This is just going to be a brief primer. We're not going to get too in-depth into all of the ins and outs and details. We're going to cover a lot of the ground, just the basics, things that will help keep you out of trouble, kind of give you a taste, as it were, of what the Open Meetings Act is and how it applies to your responsibilities as a school board member. So going forward, let's see. So the Open Meetings Act in a nutshell kind of comes down to these three particular things. All meetings of a public body must be open to the public and must be held in a place available to the general public. And then all decisions of a public body must be made in a meeting open to the public. And that kind of feeds back to the meetings of the public body. And then all deliberations of a public body constituting a quorum of its members must take place in a meeting open to the public. These three sentences carry a lot of weight. They come from the Open Meetings Act, but really you got to kind of pick into what our bold words are, what those actually mean to really understand what our purpose and what we're looking at doing with this is. So we're going to kind of go from the bottom up on this. And the first real question is the difference between decision and deliberation, because we do have two different aspects in that way. Decision is defined in the Open Meetings Act as a determination, action, vote, or disposition upon a motion, proposal, recommendation, resolution, order, ordinance, bill, or measure on which a vote by members of the public body is required and by which a public body effectuates or formulates public policy. As you all probably know, as a school board member, you yourself don't have much authority in and of yourself. The school board, as a member, the 7 members, when you make a determination by a majority of the board, that is the board speaking, and you do that through your votes. Decisions can be made. You have different ways that you can do it. If you have a vote of acclamation, if the president says all those for and everyone says aye, and opposed and nobody says anything, the secretary can take down the notes and say everyone voted for it. It was a unanimous decision. And we'll talk a little bit about what the ins and outs of what decisions are as we get a little bit deeper into this. But it is the board that is taking that action. You're doing something that indicates that the board, by whatever that vote comes out, is doing something. So decision, pretty clear. Deliberation, not defined in the Open Meetings Act. It can be a lot of different things, and there's some contours about it that you have to be aware of. Where you can deliberate, how you can deliberate, when a deliberation is occurring. They're supposed to be in your meeting. They're supposed to happen there, but there's some soft spots on that where if you're talking with another board member, that's okay. But once you start changing the dynamic of what you're doing, so there's a couple cases that kind of help give us some guidance on this, because the Open Meetings Act doesn't. First, we should probably talk about what deliberation is as defined by Merriam-Webster. The act of thinking about or discussing something and deciding carefully, or a discussion and consideration by a group of persons, jury, legislature, school boards, of the reasons for and against a measure. So it's really where you start talking about the things, and you're supposed to have those deliberations in your open meeting, unless it were exempted, you were in a closed session, and then you can have deliberations in those. But you have to be very careful to distinguish between your deliberation and an actual decision. So decision line is something that just being aware of it. So there's a couple of things that you should know. If you're using a consensus building process, that process, if you're talking with people and negotiating, if you're not in your open meeting, then you're violating the Open Meetings Act. And this comes into a play in a lot of different aspects. Some of them can be if you're sitting in your meeting and you're texting with other people on the board in your meeting, you're actually having a secret meeting within your meeting. If you're chatting about the different topics that are in front of you or complaining about another board member who's waxing eloquent about a viewpoint that you disagree with, you're probably violating the Open Meetings Act. So you need to be careful about that. As well, consensus building, as you see here, it says, using a consensus building process equates to decision-making outside of the open public meeting, but informal canvassing is okay. And that's an important thing to kind of understand the difference. And there is a very big difference between if you call one of your other board members and go, hey, what do you think about this? Are you going to vote for it or against it? And they go, I'm going to vote for it. And you go, okay, cool. Because you're just kind of getting an idea where other people are. Where you start getting into a problem is if you start talking to that first board member and they go, well, I kind of like these things, but there's this aspect that I don't like, and that's why I'm voting against it. And you go, okay. And then you talk to another board member and they say, well, I like this aspect, but this one is a problem for me. And you go, well, let me go back and talk to my first person and kind of see if they're willing to give a little on there. Now you're wheeling and dealing, you're deliberating. And unless you're in a meeting kind of hashing this out in front of the public, you're in violation of the Open Meetings Act. Another aspect is a question of the secret ballots. It closes off the vote, and you can't do that. One of the clear clarion points of the Open Meetings Act is all of your decisions have to be in an open meeting. You cannot make your decision in closed session and then come out and say, well, we took care of that. You can't deliberate and make a decision informal, really, in your closed session, and then come out and go, well, we took care of that, and so we're just going to vote it out real quick and be done. If it becomes clear that you guys built your consensus, you know, everything was all kind of lined up and figured out in your closed session, you can run into some problems. Secret ballot is a scenario, and it's happened in a couple times, as in Esperance versus Chesterfield Township. They had a meeting in the public, but they were struggling as far as two people that were running for the chair. The two names that were put up, I believe this is that case. They had a secret ballot just to kind of see where it came out, and then the one person withdrew, and then they nominated the person that had remained in the race. You can't do that, especially in scenarios where you have two people running for a particular office, and it can lead to some hurt feelings that could occur. You still have to have those votes in public. It's harder in scenarios where you're looking to appoint somebody to your board, where you might run into a 3-3 scenario. 3 want this candidate, 3 want that candidate, and you have to kind of go forward and have your negotiations and debate the merits of that person and deliberate in the open meeting. So what's a meeting? And that also becomes an interesting question. This is defined in the OMA as the convening of a public body at which a quorum is present for the purpose of deliberating towards or rendering a decision in public policy. So a couple aspects about this that are important to keep in mind. Workshops, retreats, work sessions, committees of the whole, study sessions, and other discussion-only gatherings are still meetings. So even though you're not planning to vote on something, you've never had that intention, it's still a meeting. You still have to meet the requirements for the Open Meetings Act. Because there's the potential that you could deliberate on something. There's the potential you still can vote on things in these meetings. There's not a requirement under the OMA that you post an agenda and things can change. So you have to make sure that you're complying with the Open Meetings Act, even for all of these sorts of things where you're gathering, because you are really deliberating on things, even if you call it discussion. Another aspect to keep in mind, and we talked a little bit about this, the splintering of your quorum. if you start doing that shuttle diplomacy, I called Bob, Bob said he liked this, I called Jill, Jill said she liked that. I tried to work with Bob and Jill, and then I added in Joey. You're doing your shuttle diplomacy, you've got your constructive quorum. There are other scenarios that can be problematic as well. If you have, say, 3 board members that are sitting down with a group of the community to do kind of hearing information from them, complaints about the district or something. It's that sort of scenario. And then a 4th board member shows up, you suddenly have a quorum of your board and you didn't do the posting, so you violated the Open Meetings Act. One of the issues that can come up with that is people have tried to find ways to work around that. They did, well, one of us will step out, so we'll only have 3 in the room, and then the 4 people are there. Or 3 people are in there and 1's outside. So it's not really quorum, except for the fact that the courts have found that that sort of scenario is quorum. So kind of the lesson to take home from that is you don't really want to have a scenario where you're showing up at meetings that you're not supposed to be at. There are some scenarios where it's not a meeting. And those are if it's a chance meeting, if 4 of you happen to run into each other at the grocery store at 2 a.m. buying milk, it's not a meeting. You can say hello to each other. You can, as long as you're not chatting about the board, that's fine. If you're going to events that are geared sort of like an MASB or ALC as an example, if your board shows up to it, it's not targeted specifically to your board in and of itself. So all of you can be there. That doesn't count as a board meeting. Again, provided you're not discussing board business. So those sorts of scenarios are things to keep in mind on this. And then obviously, if you have more questions about that, we can talk about that towards the end. So then comes the question, what counts as a proper meeting? So this is how we're going to talk about having a proper meeting. You have to meet the posting requirements. And there's a couple different versions of that. So at the beginning of your year, you have your regular meetings that you establish, usually at your organizational meeting. Those have to be posted within 10 days of your organizational meeting. If you're making changes to this schedule, it must be posted no more than 3 days after the meeting at which the change occurs. So normally you'll get, at your organizational meeting, you'll set up your calendar for the year so everyone kind of knows when those days are. As an interesting little point, technically that's the only time you have to post notice about those meetings, provided you're not changing them. But as a general rule of thumb and a best practice, it's always better to overpost. When the meeting is coming up, just post it again. That way, if something got changed or something got missed, you're still covered. Better to overpost than underpost. Special meetings and rescheduled meetings must be posted at least 18 hours before the meeting. And that is in the statute. So if you have to call a special meeting, you have 18 hours to do it. If you've rescheduled a meeting, same thing. Reconvened meetings, it's a little bit of a different animal. If you recess a meeting because it got controversial, things were getting a little heated, or it just got really late because things were going on, you can recess it to the next day and then come back. You have a 36-hour window. If you go beyond that 36 hours, then you have the 18-hour requirement before you can reconvene that meeting. It creates an opportunity if you're going to say we're going to take a break, it's kind of run through lunchtime or a dinner time. We're going to come back in 2 hours. You don't have to go through a posting requirement for that. If you're crossing 36 hours, that's more than enough time. Your meetings have to be open to the public to attend them. You have to make sure that they're available, accessible. You can't have it at like somebody's house or behind a closed door. If you're having a meeting at your local private athletic club where the general public can't get in, but you go, the meeting's open to the public, you've actually violated the Open Meetings Act. So you have to make sure that wherever you're going to have your meeting, public can get in, no hindrances in front of them. You have to allow for public comment in your meeting to occur. This one can get tricky, especially if you have controversial issues that are coming up. There's a lot of nuance as to how you go about getting information of who is going to speak. A lot of districts have started creating a sign-in for it. You have to give notice, at the very least, a name. You can ask for other information. You can't deny somebody to speak at your meeting because they don't live in the community. You can't deny them because they didn't tell you their address. It can be useful information. You can ask for it. And usually you might ask for it because if somebody's asking a question of their board in their public comment period, you want to answer them, but not right there. You want to be able to do your homework, get the information put together, get the right answer to them. And usually that would involve saying, if we have your address, we can send you that information. People may give it, they may not. But the creation of your list is an aspect. That way you can run your orderly meeting. And so that's been found to be okay to have your list of people. A question that has not been answered of when you can close that list. Some districts close it right when the meeting starts and they go, that's it. Some close it right when they get to their public comment period. And those are good times, I would think. You don't want to be the vanguard on this and find out that closing your public comment list 3 days before your meeting is actually a violation of the Open Meetings Act in the spirit and probably the law. But those two timeframes tend to work on that. You only have to have one public comment period in your meeting. And you can put it where you want in your agenda. So again, some districts, a lot of districts do it in different ways. Some districts will have it at the very beginning. You know, they'll get through the gaveling in, maybe the pledge, a couple quick things just to kind of take care of, and then they'll have their public comment period. Some of them will have it at the end of the meeting, and you don't have to keep it at the same place. You just have to make sure you have it. Some districts will have multiple public comment periods, but they'll limit ones that they have to the issue being addressed on the agenda. So if there's some controversial matter that's going on in the community and you want to kind of keep people to that particular topic, you can keep them on that. Or if there's a controversial topic in the community and this kind of low level thing, but people will want to comment on, you can separate those out. You just have to make sure that you have your general public comment where people can address things that are germane to the board. The topics need to be to what the school board does. If somebody comes and they start complaining about the local school, you know, the local government, your township, your city, you could say that this is a school board meeting. But generally you're not going to want to stop them unless they get really kind of out there. Your public comment can be limited. You can make sure that you're not letting somebody go forever. You can limit them. We generally recommend about 3 minutes per person, not less. You can go more if you wish, but that tends to be about the point where somebody can introduce themselves, kind of say their piece, and it's been viewed generally as enough time for somebody to get their point across. Going less than that is a problem. That is generally kind of run into some issues. One of the things of establishing your time limit, be it 3 minutes, 5 minutes, whatever you're going to do, whatever your policy is, you have to make, especially with your policy, you have to make sure that all the people that wish to speak, if they've signed up on your list, if you have that, that they are able to speak. You can't say, well, we allotted a half hour, we've used it, so I guess all you other people don't get to speak. You have to allow for everyone to speak, and your policies should allow for that sort of extension. The other thing that I want to kind of give high point on this is you want to be sure that you are consistent in measuring your time. If you have people that you are talking and you love what they're saying, they get 3 minutes. If that's your policy and you say 3 minutes, that's what you got to do. If they're saying something that you really disagree with and you think it's terrible, they get their 3 minutes. Can't shortchange people. You can't give people longer time. That's an important aspect, because if you start doing that, people are going to start bringing complaints, and then you have a lot of open meetings violations to contend with, which you don't want to do. You have to take minutes of your meetings. And the minutes, if anyone's ever read the minutes of their meetings, you can often look at them and go, how did this meeting take 2.5 hours? There's like half a page here of things that we did. And yeah, it's because you talked about one big thing and or your public comment took a really long time. And when you look at the public comment, it says public comment was given. The minutes have to record votes. That's really the big thing about them. It shows what the district decided. So as long as the minutes are very clear on who voted which way, that's the important thing in there. And so, like I said earlier, if you have a yeas and nays vote and there were no nays, so it's obvious that it was unanimous, the secretary can write it down. Kind of the rule of thumb is if it's clear to everybody in the room that's watching the meeting, that can be your clarity mark. If your president asks for support and against, and some people support, and then you hear no's for the people against, then you need to kind of identify, be it by roll call vote or by hands, whatever scenario you want to wish. There are a couple scenarios where you need to have a roll call vote, but well, that's kind of deeper in the weeds. So you just have to make sure that everyone knows how everyone is voting in those meetings. Let's see. Closed session. So closed session is a interesting aspect. There's under Section 8, there are certain exemptions that allow for you to go into a session where you're not in front of the public. We're not going to get too deep into the details of those. Generally, it's if you're hearing complaints about somebody on the staff, if there's a disciplinary hearing on a student, it's those sorts of things. But an important aspect about it is any decisions that you're making to hold any portion of your meeting in a closed session have to be made in your open meeting. So there's some scenarios, a majority vote is required, and some scenarios where there's a 2/3 roll call vote that's required. It depends on the purpose. But when you go into a closed meeting, you can't take action during the closed meeting. You have to come out into the open meeting and have your vote. If you're doing an expulsion hearing on a student, you're not saying the student's name, you're not giving any real, specific details, but you're going to come out and you're going to make clear that you're having a vote on, an expulsion of a student or a disciplinary action on a student or on a staff members, whatever the case may be. And you're going to have to vote on that in front of everybody as the board. Even when the school board's permitted to conduct your closed meeting, can't take your actions there. There is, once legitimately in closed session, you can deliberate on the topics for which the closed session is called, but the decisions have to be made in your open session. A couple other things you should keep in mind about that. When you go into closed session, you have to be careful that you're just talking about the topic you're going back for. It's helpful to kind of keep yourself focused on that. You can go back for multiple topics. You don't have to go into your closed session on one thing, come out, go back into for closed session for a second thing, come out. You can list, we're going to go into closed session on, these 3 things. The only thing you have to be careful about is if one of those things requires the 2/3 majority, you have to hit that 2/3 majority for that one. And by default, you would hit the majority for the other ones. So it's just something to be cognizant of when you're going into closed session, especially if it's on multiple topics. As we were saying, deliberations are okay, decisions, no. The Court of Appeals has ruled that a public body violates the OMA when they use informal voting procedures in closed meetings. So your consensus building in your closed meeting, you can't come to a decision. You have to be very careful about that as you're getting closer to that point of where to kind of draw the line and go, okay, so everyone got all their questions answered? Have we, everyone's kind of figuring out where they're going, okay, then you go, then you leave your closed session, go out into open session and come to your decision. Let's see. There is one exception about this, and it is kind of one that's reasonable to talk about right now. The Court of Appeals has interpreted the word deliberation to permit a school board to establish a consensus and develop a course of action for purposes of collective bargaining. So your collective bargaining strategy. Kind of the easiest way I have to describe this is if you're going in to talk about, how the negotiations are going, your bargaining team people are going to tell you this is what the union wants. This is what, you've given us as directive of, what we need to look at. This is how they meet up or how they don't meet up. Are we changing position? Are we going, what's going on here? Or when you're even establishing your initial requirements. If you're doing that in open meeting, you're setting your bright lines. If you tell your bargaining team in closed session, okay, we understand, people are going to want pay raises, but we've looked at the numbers and the maximum that we can do, looking at what our budget is going to be and from the information you've given us, the maximum seems to be 3%. We can't go higher than that. It's just not possible. If you do that in closed session, your bargaining team then knows that they can start at maybe 1%. And when they go, well, we want 2%, they can go, well, okay, we'll take it. We'll see what we can do. If you do that in open session, what you've basically done is you've told the union 3%, go ahead and ask for that because now you know where our end of the line is. So allowing you to have those conversations in your closed session. The other aspect is it doesn't produce a decision because it's not the final determination. So a distinction here, if you're going to talk about your collective bargaining strategy or collective bargaining sessions, whatever you're going to handle there, that is a different thing than your ratification vote. When the contract comes up to the board and it goes to the union, that's a final vote. That's you approving the contract. So that has to be done in public. You can't do that before. Now, arguably, everything has kind of come along, and so it shouldn't be that difficult. A worst case scenario, I think, for any district dealing with their collective bargaining scenarios is when a contract is brought up to the board and the board says no. That's terrible. Whether the union agrees or they get a majority of their membership to agree with it, that's their issue, that's their problem. But the board, you don't want to be in a scenario where you're given a contract and you read it and you go, this is nothing like what we had talked about. Our top 5 closed session violations. Number 1 is making decisions in closed session. Again, you have to be very careful when you start getting up to that line and people are kind of making up their minds on things. Make sure you come out before you've kind of hit that point. 2, discussing individual administrative contracts in closed session. So we talked a lot about the collective bargaining aspect. On an individual administrative contract, all of those have to occur in open session. So if there's questions about it, all of that has to be public. Citing personnel matters as a reason for calling a closed meeting. If there's a complaint against an administrator or a problem that you're looking at, you don't have to get into like ridiculous details about it, but you can't just say personnel matters. You have to be a little more clear on that. 4, discussing oral legal opinions from legal counsel without a pending lawsuit. So if there is a pending lawsuit, and that means that the lawsuit has been filed, you've received service, you can go and talk about that in closed session. People threaten to sue all the time. The threat of a lawsuit is not enough to get you into closed session for a pending lawsuit. Has to be filed. You can go for written opinions from your legal counsel. So if you've asked your counsel to give you a written opinion on something, there's a method through that to be able to go into closed session for that. But if you want to get an oral opinion from your attorney, he's there at the meeting and you go, we want to know about this, but let's go and not do this in public. You can't do that. So you got to be careful on that one. And then as we had talked a little bit before, exceeding the scope of your closed session. If you're going back for one purpose, stick to that one purpose. If you're going back for 2, stick to those 2. And it does happen where people start kind of drifting off into something else and you start talking about the safety precautions or the new safety measures that are coming into the school, even though you went back to talk about the labor contracts. And, you know, it can be a totally organic shift in the conversation. You know, teachers are saying they want something a little more, a little more secure in the building, whatever the scenario is. I'll leave it to your imaginations. And then you go, well, I mean, there was this one contract the guy brought in that, you know, he wanted to put the door locks on or what, and you've kind of drifted out of labor negotiation into building security, but you didn't go back to talk about building security, so you can't do that. That kind of covers the top 5 things. As a little bit of a side note, and it's kind of important, when you're in closed session, you have a separate set of minutes. They are not minutes available to the public. They are minutes that are available for the purposes of if there were litigation to follow. And those minutes are actually kept for a year and a day. If nothing comes up, then those minutes are destroyed. And they are not public. Things that occur in your closed session are not public. And there have been questions about what happens when a board member starts talking about that. You know, they had this conversation in closed session. That's a problem. So the Attorney General has ruled that a public official who discloses closed session minutes to the public in violation of the Open Meetings Act risks criminal prosecution and civil penalties. Michigan courts have interpreted that the disclosure restriction to include not only the actual minutes documents, but also include dialogue that occurred during a closed meeting, even if not recorded in the minutes. And so that those conversations, that's really where problems start arising. So if it happens in closed session, don't talk about it. Our best practice is to say that don't publicly discuss with anyone other than a closed meeting participant or other school board members who are unable to attend the meeting. I would generally say if you can avoid talking about it at all, that's going to be your best line. If somebody needed to vent about something or what have you, just make sure where you are, that there aren't people around that could hear. These are important aspects to this. So, what is a public body? And this has become a little bit of an interesting thing for people in the most recently. Public body is defined in the Open Meetings Act. Any state or local legislative or governing body, including a board, commission, committee, subcommittee, authority, or council that is empowered by state constitution, statute, charter, ordinance, resolution, or rule to exercise governmental or proprietary authority or perform a governmental or proprietary function. And there's a couple things I want to highlight here. The obvious, the underlined section. If there's been an empowerment for them to perform governmental or proprietary functions or exercise those authorities, that's something that makes it so it's subject to the Open Meetings Act. And then we've italicized committee, because committees are kind of a weird creature now. The Supreme Court's articulated 2 pathways to determine whether a governmental entity is a public body. So whether the entity satisfies the above definition by its own right. So sticking with committees, if it's a committee that has, you know, by rule, whatever your policy, or your school board does it automatically. It meets those requirements. Or the entity has delegated authority from another public body. So this is our committee. If the school board gives a committee certain authorities to do something, make decisions, whatever the case may be, then that is a public body that would be subject to the Open Meetings Act. Committee is a little tricky to figure out. So generally, is a committee a public body? Yes, if the school board delegates its governmental authority to the committee to perform the governmental function, then it becomes a public body. We were talking about this just the other day. If you delegate to a committee something that is just going to be information gathering, they're not making decisions, they're just putting things together and bringing it up to the board, that is probably not going to meet that line. but there are other scenarios where they do. One of the questions that we've started kind of chewing on is if you've appointed a committee, may not even have any board members on it, but you've created a committee to handle something as a board. You made that committee, so you've delegated that authority, say for reviewing a book title. If somebody brings a complaint about a book in the library. So you build this process so it can be reviewed, and then that committee is going to make a decision whether or not, a decision or a recommendation to the superintendent, some sort of scenario of this book should stay, this book should go, whatever the case is. Likely that committee has to meet open meeting requirements. So those requirements, they'd have to post the meeting, they'd have to have a public comment period, they'd have to take minutes of their meeting, they'd have to do all those things. But if it's just limited to the information gathering without making decisions, then it wouldn't be subject to the OMA. So it kind of gets, what is the committee doing? And we talked a little bit about, so the committee's empowered to do things, the Booth Newspapers versus University of Michigan Board of Regents. This was a case that went really, really far. U of M Board of Regents was looking for a new president. They appointed themselves as a committee of the whole. They then empowered the board president or the regent's president to go ahead and make a cut. They picked 250 people that they thought would be great as the president. Then they kind of cut it down initially to 70, just from the president going, well, these people aren't interested. These people want to do different things. These people are interested, and then they cut it down again. And they did all of this in closed sessions, not in public. And then they just kind of announced, here's our new president. And, the board then voted on the new president, the one person out of the 250 or so that they had started from. And it was found to be a violation of the Open Meetings Act. Of course, the takeaway from all of this is after that court case, universities went and they got an exemption put in to allow them to have their presidential searches in private, but that's a whole different Lansing government politics thing. Schmecke versus the Clare School Board. The school board appointed a committee whose membership consisted of less than a quorum of the board. Committee had two tasks: to review whether the district should retain its method of evaluating administrators and to recommend whether the length of administrators' contracts should be changed. So they're gathering information. They can make a recommendation. Upon receiving the committee's recommendation, the school board took no action. And the Court of Appeals ruled that the committee's refusal to admit the public to its meetings violated the OMA because the committee made a decision at its meeting. It decided not to make a recommendation. The committee was also engaged in deliberations on public policy when it met to determine what its recommendation would be. The school board's referral to the committee was a delegation of authority to perform a governmental function, despite the fact that the school board did not intend to delegate final decision-making authority to the committee. The real takeaway out of this one, in my opinion, is make sure you close your loops. They delegated this authority. The committee said, we're all good. We don't need to make any changes. You can look at that in a couple different ways. Either they did not make a recommendation or they recommended the status quo. But to close that loop, you want to be sure you say, okay, we agree with your position of not changing anything, having a vote on that. It closes it. It makes it so the authority still remains with the board. And that has become even more important from a committee's aspect with this most recent case, Pinebrook Warren LLC versus the city of Warren. So the Michigan Supreme Court decided this case July 31st last year. Warren City Ordinance established a review committee to evaluate applications and make recommendations for medical marijuana dispensary licenses, but it did reserve the final decision-making authority with the city council. Their review committee had met 16 times, mostly non-publicly. Towards the end, they started having some public meetings, like the last 3. They reviewed submitted plans, they questioned applicants, they heard presentations from them, they ranked and scored them. Then they transmitted their list of their recommendations of granting licenses to the top 15 of the 65 applicants. So this was a little bit more than, here's 65 applications, you guys go compile them. All of the information is there. They did a lot. The city council discussed the recommendations for about 20 minutes before approving it. So 65 applications, they didn't really talk about them. They basically, these are the top 15. Is everyone good with those? No one's got a real issue. Okay. And so it created, they were then sued. Pine Brook Warren and the other 49 entities that didn't get their license said it was an open meetings act violation. In the Supreme Court, it went up the whole system. Supreme Court held that the review committee was a public body because it was a governing body and empowered by the marijuana ordinance to exercise the governmental function of scoring medical marijuana dispensary applicants. Even though the marijuana ordinance said the review committee had only the power to make recommendations, the review committee was the governing body because in reality, the review committee ranked the applications and effectively decided which applicants would receive license. The city council didn't do the work. So the review committee had to comply with the OMA. On this case, the court's analysis, they said to determine whether a public body has provided its authority to the different entity, thus subjecting the second entity to the OMA, a court must examine both the language of the enabling action and the actions actually taken by the second entity. If the second entity makes public policy decisions that would otherwise have had been made by the original public body, according to the law, then the second entity is also a public body covered by the OMA. There have been a couple cases where things like this have come up. The city of East Lansing had a lawsuit where they were making determinations on a contract, for some architectural contracts, and people met. The committee that was established met in private multiple times, and then they kind of came out and had a couple public meetings, and the same sort of thing happened. But here we have a Supreme Court case that's very clear about this, saying it's not only just what the ordinance says, it is also what the committee actually does. So committees making recommendations, if you're providing all of the information that you had, it can still make a recommendation if they were empowered to do so, but you have to be very, very careful about that. So kind of the true takeaways of the key takeaways from the committee cases really are a true advisory committees. It's not subject to the OMA. They identified preferred options and recommendations to the board, share all options considered with the board, but the board retains authority to accept and reject the recommendations. If you think back to the marijuana case, the board said they retained that authority, but they didn't do it. They just went, okay, yeah, here we go. We're going to work with this. So this concept of a true advisory committee gets a lot more murky. Committees will likely be subject to the OMA if it engages in practices of eliminating or narrowing down options. And so this could be a scenario if the committee is exercising authority to preclude matters from reaching the full board. Was the board a rubber stamp? It's the function, that's determinative, not the title. So even if you send down to a committee, here's a bunch of applications, just go through and see who met the minimum requirements. Did they dot all their I's, cross all their T's, sign where they're supposed to sign? And if you, as the committee, go through that and you find 5 that they didn't sign the things, if you're going after to get them to sign it, maybe it would be okay if you send all of them up and go, these 5 didn't sign it. Did you make a determination there? That's where we start kind of running into question. Generally, as a best practice, what we are recommending, if you're unsure, or even if you're sure, just post your committees. If you post your committee and it's no one's going to show up anyhow sort of scenario, you're going to lose 3 minutes of your life to, are there any public comments? There are no public here. There's no public comments. Fine. better that than the alternative where you do something in your committee and somebody else didn't like it, so they sue you under the Open Meetings Act. And you have to kind of litigate through whether your committee met that requirement or not. And even if you win, you're still looking at a scenario where you've paid a lot of money to have that problem. You can avoid all of that just by posting. So that's where our recommendation is. That kind of concludes my slides. Let's see if I can't figure out how to, there's a lot of things in the chat. I don't know if anything showed up in Q&A.
Got all the questions covered in the chat, Dan.
Okay.
Nothing in the Q&A at this point. There was one issue in the chat I wanted to provide further clarification on, if I could.
Yeah, by all means.
So the issue was live streaming a meeting to the public. And is that technically subject to the Open Meetings Act? And it's not. So under OMA, you're restricted from having a full virtual meeting. And the only way you can have a virtual meeting in part is to allow the accommodation for a virtual meeting for a member of the military who serves on your board, and that person is unable to attend the meeting due to military duty. You know, there's also the ADA exception where if someone has a disability, they may be granted virtual meeting access as well. But if neither of those two issues apply, and a board is just live streaming a meeting to the public, that's not covered under the Open Meetings Act. So the physical meeting that the board is covering is covered under OMA. And because the physical meeting is covered, that's why we recommend anyone participating in public comment should be at the meeting physically, rather than participating in the chat box or participating through public comment live streaming, because we just don't know what the regulations would be, because OMA doesn't cover that. So I just wanted to provide that further clarification based on the comment I made in the chat box.
Okay. Get any other?
So it looks like we do have a few more questions here. I will read them to you. And you might be able to see them yourself. A school employee was terminated and the board wants to get the details behind the termination. When a cause appears to have resulted in the employee resigning, can the board go into closed session to discuss rather than talking at an open meeting about an HR related matter? How would you suggest handling?
That's an interesting question. So one of the issues that you could run into on that is, in order to go into a closed session to discuss a disciplinary matter, or discussing employee issues or even student issues, is it has to be requested by the person. So in the case of an employee, if there's a disciplinary or a review or evaluation, they have to request it, and then the board votes on it. If they don't request it, you can't go into closed session. On students, it's the same thing, but there is a workaround on that. So in scenarios where if you're having a disciplinary hearing on a student and the student or the parents don't request closed session and show up, whatever the scenario is, because you're handling student records, under FERPA, you can go into closed session that way and then have that conversation about it. But as far as an employee's records, it's their call.
Another question here, Dan. Once a committee meeting is posted, it is now subject to OMA, even if only 3 members and no decisions are being made.
Yeah, I would say yes, because it's a quorum of the committee at that point. So where it gets, I think it would get more interesting is if you have a committee that the board has created with an ordinance that doesn't have any board members on it. It's, however many members of the committee that you've put onto it, whatever the number is, I suggest doing odd numbers on those committees. So whatever gets you over the halfway mark, that's your quorum. If you post a meeting, and this goes for your regular board meetings too, and something happens, you don't have quorum at the meeting, you can't have a meeting, you can't have votes, but you can still listen to presentations that were there. You can do some of the things. You can't vote on things is really the thing that you can't do at your meeting. You can still have public comment, just no voting.
And add to that, Dan, I would suggest when you're looking at your committees being subject to the Open Meetings Act, all in or all out. Okay, I don't like the okay, we'll post it open to the public, but we're not going to allow public comment, or we're not going to worry about minutes. If you're 100% confident that it's truly advisory, then you're all out. But if you want to err on the side of openness, go all in on complying with OMA, saying that you're posting it, 18 hours notice, you're taking minutes, allowing public comment, doing everything openly and transparent, fully compliant with OMA.
Yep. We have another one here. If a board goes into closed session for a personnel matter related to a staff member, does the accused staff member have a right to join the closed session? They do not have a right to join the closed session. The board can bring whomever they wish to bring into closed session. But they don't have to, or you can have them come back and you can excuse them. But again, the one caveat on this is it is the individual's discretion. So if you have an employee back there and then you go, okay, we've heard all the things and now we want to talk about this. That employee does have the right to rescind their request for the closed session, thereby forcing all of you to go into open session to have your deliberations. So you can have them back. It generally is probably a good idea, but it's not a requirement. And we have giving the way technology is advancing, having meeting participants online would be helpful for translation purposes and families of whom English is not their first language. Seeing the law being revised in the near future. Probably not. The focus on the Open Meetings Act is the meeting itself that is occurring. You can have your 7 board members attending a meeting physically and have all of your presentations coming in virtually. You can stream them in because they are not members of the board. They're not required to be there. They're by your invitation. They're presenting something to the board. They're not voting on things. If you have a translator, I get you could have somebody that's doing that, but they're not a board member. So, and you can broadcast multiple languages with technology if you want. I don't see the law changing on that anytime. If an employee resigned and not present for the board member wants to know the details behind the resignation, should they just talk one-on-one with the soup? I would tend to think that's probably the best course of action. It's certainly because you can't get into closed session unless they agree to have this, even if it's a post-resignation disciplinary conversation. So the one-on-one is probably going to be your best bet. Can a hiring personnel committee narrow down job applications for interviews? Then recommend one candidate to the board for hire. That's an interesting question now in light of Pine Brook. There is an exemption that allows if you're interviewing for for people to keep their applications confidential to a certain point, but that's that interplay is going to be an interesting question on how that works out.
I'll just comment that school boards are a very unique public body. And unfortunately, these other committee cases are addressing public bodies that aren't subject to the same type of rules and laws that school boards are. So the question that Dan just asked, I think obviously it wouldn't make sense for your administration, to be conducting all of the teacher interviews and all the committees relating to hiring teachers in open session subject to the Open Meetings Act. That's just not workable for a school district, but someone could interpret those cases to require that. So we can't recommend today that those type of committees should be open to the public and fully compliant with the Open Meetings Act. That's the issue that we struggle with committees, because these committee decisions are addressing other public bodies that have different laws and regulations associated with them than school districts. So it's hard to kind of put all these committee decisions and guidance into a one-size-fits-all approach, is kind of where I'm coming from.
And looks like we have can real estate discussions be conducted in closed session? Some of them. You can have discussions in closed session. I don't have it up in front of me, so it's a 50-50 shot here. If you're going to, if you're looking to purchase something, there we go. And same sort of thing. If you're figuring out what's the maximum you want to purchase, if you're making that determination in a public meeting, what you're really doing is setting the floor, because now whoever is selling that property knows how much you're willing to pay. And there's a line that you can get to on that. If you purchase an option, when the option comes available, then your final vote of we're going to buy it, we're not going to buy it, that has to be out in public. We got public commentary is a person for regular Board of Education meetings. What if somebody with a disability can't attend the meeting due to disability, but wants to participate in public commentary? Under the ADA, you're supposed to give reasonable accommodations. And there was an Attorney General opinion that kind of talked about this as far as dealing with board members and to some degree the public. Your definition of a reasonable accommodation, maybe it's that you let them address, but they have to meet all the requirements under the ADA to qualify for it. It could be that you just go, we're willing to read your comments into the record and have somebody here read it for you because you can't physically be here. You don't have to then open your meeting back into the two-way for the general public and allow for public comment virtually for everybody. So just, and you probably want to try to avoid that, just because then that can run into problems, especially if you have bright line controversial issues. If a district scheduled a workshop, can they go into closed session during that workshop, or would they need to wait to add that to the agenda for the next meeting? Well, if you're having a workshop, and I'm thinking like an MASB workshop, you're having a regular meeting anyhow. Well, it would be awkward, I guess, if you're in the middle of your presentation to suddenly go into closed session on something. It could happen. You don't if you adopt your agenda at the beginning of the meeting under Roberts, you would have to have votes to alter your agenda, but you don't actually have to have an agenda. So you can go into closed session, but it has to be for one of the reasons that are legitimate for closed session.
Yeah, and that workshop would be a special meeting under OMA. So as long as you're complying with all the special meeting requirements that Dan covered, you could go into closed session during that workshop. Sometimes boards just like to identify special meetings as workshops, study sessions, work sessions, retreats, committee of the wholes. All those are special meetings under the Open Meetings Act, regardless of what you call them.
And then are board retreats subject to the Open Meetings Act? Yes. Post it, have your public comment, then have your retreat. Okay, it's 1 o'clock, at least by my little computer clock. If there's any other questions, you can feel free to reach out to Brad and I. We're more than happy to have conversations about these things. We'd love it when you guys stump us. It's hard to do with Brad, but on a rare occasion it does happen. So thank you very much, everybody.
All right, have a good day. We'll see you.